Well, happy Thursday. It's Illinois in Focus Daily. I'm Greg Bishop. We've got 4 things we're going to talk about today, so hopefully you buckle in and get ready for conversations about new technology being implemented by state police to alert drivers about roadway conditions, including whether there's a stranded vehicle or road debris. We'll also hear Governor J.B. Pritzker being asked about a couple of different issues. One, dealing with the Mahomet Aquifer and carbon capture, whether or not some drinking supplies are going to be harmed by efforts underway to capture carbon dioxide. Some of the other things that obviously the governor has having to address is allegations of abuse at state-operated child welfare homes. So that's an issue that I don't think is going to go away anytime soon. So we'll hear about that. But up next, I want to give you the play-by-play from yesterday's hearing in the Schoenthal versus Raoul case about the prohibition of concealed carry on public transit. This is a hearing that took place yesterday. I tuned into it, and if you followed me on X, then you saw all this play out. Pretty fascinating. Something we'll tackle when we return with Illinois in Focus Daily. Right here with America's Talking Network. Like, subscribe, hit that notification bell, and join us each and every weekday morning for Illinois in Focus Daily. Federal judge denying the state's motion to stay his ruling against Illinois' prohibition for carrying concealed firearms on mass transit, while also not sanctioning the attorneys that wrote a controversial sentence in their motion for that stay. I was able to tune into this hearing yesterday, and we're going to review all of that here with Illinois in Focus Daily. I'm Greg Bishop. Be sure to like, subscribe, hit that notification bell with America's Talking Network, and join us each and every weekday morning as we go live with multiple stories each and every weekday morning at about 8 o'clock here with America's Talking Network. But if you go to thecentersquare.com, where I'm the associate editor, you'll be able to see the story about the federal district judge denying the state's motion to hold his ruling against the prohibition of concealed carry on mass transit. This case filed back in 2022. You have 4 plaintiffs involved, and on the briefings that were filed, the judge ultimately made a ruling that it violates the Second Amendment to prohibit individuals who have concealed carry licenses in the state of Illinois from carrying their concealed firearms on mass transit. So when that ruling was issued in late September, you had the state say that they were going to appeal, but they also wanted to hold the judge's ruling, which only impacts the plaintiffs. And I think that's important here. It's not a ruling for the entire state for all concealed carry license holders to be able to carry their firearms concealed lawfully on a public transit, but just for these 4 individuals. So the judge made this ruling for these 4 individuals as it goes to the appeals court. You have the State Rifle Association saying that they hope to expand it in the appeals court to allow for this to have impact on everybody. But in that filing that the state made against this ruling, trying to say, hold the ruling because there's the possibility of irreparable harm, because this could allow for people to have firearms on mass transit. And the sentence that they wrote in their filing caught the judge's attention when they said something to the effect of that 3 days after the judge's ruling, there was a quadruple homicide on the CTA Blue Line from somebody who carried a firearm on the train. So the judge read that and demanded that the attorneys that wrote this in defense of the law answer to questions, and that hearing was yesterday. So I was able to tune into it and break down. We'll go through all of this here with you with Bishop on air from X. So watch this. The hearing started. Case has been called. Appearances of litigants announced. You had David Siegel for the plaintiffs, and the defense included attorneys from the Illinois Attorney General's office and the Cook County State's Attorney's office. The judge says the focus of the hearing is something that he didn't think would be a big issue, but it has turned into one. Looks at the state defendant's motion to stay the ruling pending appeal. Says the filing says public interest favors stay of appeal. Judge focuses on public interest overwhelmingly favors the state. Further, in contexts of public interest, moreover, the potential safety implications of the court's order are highlighted by the recent mass shooting on the CTA's Blue Line, in which 4 people were murdered with firearms 3 days after the court's order was entered. The hearing went on with the courts discussing how does the court's order impact public safety. Judge Ian Johnston says that he'll be reading from the letter because there was a recent mass shooting on the Blue Line in which 4 people were murdered 3 days after the court's order. Johnson says the only reasonable interpretation of that sentence is that, Judge, your order killed 4 people. You're all lawyers, he said. You all understand causation, he said. He says that timing could be something used for causation. Not sure any other purpose of adding 3 days into that sentence. That's what I interpret, he said, to be the only reasonable interpretation of the sentence. And he mentions the state's filing in response, saying that it was sort of a non-apology apology. Hey, Judge, we're sorry. Goes on to ask the litigants to explain why it's not interpreted to say that the court's order caused the mass shooting on the Blue Line in Chicago. The Attorney General's lawyer said that the intent of the sentence was not to suggest that the reading of the courts, there are, from our perspective, 2 critical words there. One, no potential causality was intended. There are potential safety implications that we found on measures that relax firearms regulations. But then the judge interjected and said, did those articles cited by the attorneys for the state ever relate to a court order finding of an individual who possessed concealed carry license caused murder? Right? And I think that's a distinction that the judge was really wanting to get after here, is that that he asked for the lawyers to come in and prove if they did a reasonable inquiry into whether the assailant in that Blue Line murder had a concealed carry license and whether he was doing that in self-defense. So when they cite articles about, relaxed firearm regulations leading to more shootings, the judge interjected and said, did any of those articles cite a court order finding an individual who possessed a concealed carry license caused a murder? The attorney for the Attorney General's office tried to explain, but the judge asks his question again. The attorney says, not aware they are specifically related. So the attorney says that some do pertain to concealed carry holders from the studies he cited and the stories he cited. The judge asked how, and the attorney said that taking them in order, right to carry laws and violent crime article, with a finding that the right to carry laws can lead to increased violent crime. Again, this is something that the attorney for the state is pointing out, but the judge interjects, was it causal or just related? Opinion of authors that causal connection could be drawn. The judge firing back, could be drawn. Not that they did draw. And then the attorney responds, they did draw a conclusion about what the data could show. The judge asks about the word could, and the attorney says that those involved in the study were statisticians. The judge saying, stop. You're familiar with standard deviations. And then they have a conversation about standard deviations and causal connections and regression and statistical analysis. But then you've got the quote here, why didn't you put any of those things instead of citing the Sun-Times? You said that there's been a murder on the Blue Line 3 days after your order. In the motion for a stay, it was just to highlight one example of the result of relaxed firearms regulations, the attorney said. Judge reviewing the sentence again, relaxation of firearms regulations would have been my order, and the result is 4 people killed on the Blue Line, is what the judge interpreted that is. The attorney said that's not correct. Excuse me. I just read it. Want me to read it again? The judge said, focus now on the word highlight. Why does the word somehow magically change the meaning of the sentence? The judge asked. The attorney said that he hoped to make it clear. And didn't make it clear, did it? The judge responded. Meant to highlight the kind of harm that could occur with relaxed firearms regulations at a high level, the attorney said. The judge said that sentence implies that order led to people being murdered. The attorney responded they wanted to highlight the potential safety concerns as a result of the stay on the judge's order that the ban on concealed firearms on mass transit is a violation of the Second Amendment. The judge responding, I don't want to kill 4 people. I don't want to kill anybody. The attorney said they cited the shooting as an extreme type of harm that can result from firearms, and it was an example in an attempt to connect. And then the judge interjects the court's order. No, the safety implications, the judge says, of the court's order. When you keep saying could, that this court order could implicate the mass murder of sleeping homeless people, why is that not speculative, the judge said. Explain could. Then they talked about the word could, and now the attorney says he didn't write that in there. But the judge says you said it 5 times during this hearing. There's a good reason to believe that relaxing firearms regulations could lead to potential safety concerns, the attorney says. Then the Cook County State's attorney's lawyer speaks in and says that they don't think that there was any kind of inference in the sentence at question. We read the sentence differently, the attorney said. Not to say this court's order was related to this incident, but it's very much top of mind for public safety and the public interest. We certainly were not suggesting that the court's order was related to the Blue Line incident, the attorney said. Then the judge goes back and forth with a ton of questions. Did the court order kill 4 people? No. Did the court's order kill anybody? No, Your Honor. Did the court's order lead to any people shot on mass transit in Illinois? Not to our knowledge, the attorney says. The attorney then mentions another shooting in the Red Line that happened yesterday morning, and the judge asking any evidence the court's order caused that shooting on the Red Line. The attorney said they didn't have enough information. Another said that they are never inferring that the court's order was the cause of any shooting. The discussion about concealed carry and the law that passed, how many prosecutions of people with concealed carry licenses carrying handguns on public transit have occurred since 2014, the judge asked. The lawyers didn't have any information on that. He says he's just getting facts on the motion to stay because he said that it was a fact-free motion. And he asked the Cook County State's attorney's lawyer the same question, and they didn't have any info on that. The judge then asks how many arrests have been made of CCL holders with guns on mass transit. Any evidence they accidentally discharged a firearm on public transit since 2014? Shooting anybody since 2014? The state's lawyer says it's up until court's order it was illegal to carry. People violate the law all the time, the judge said. Keeps him busy. Do you have any evidence of the CCL holder shooting anybody on mass transit? The state's lawyer doesn't have any info on that. And this is about law-abiding citizens, right? Yes. Any evidence that they are criminals? Not aware. Any evidence someone CCL revoked because of their bringing a gun on mass transit? They didn't have any info on that. Have you guys prosecuted any CCL for bringing a gun on public transportation? No one spoke. It was silence. Must be no, the judge said. To obtain a CCL, the applicant must be qualified. Can we agree on that? The judge said. Yes, they must fill out a form and provide materials to fulfill requirements. Illinois State Police is responsible for issuing CCL after application and investigation, correct? Yes, Your Honor. The judge then says part of the qualifications, 21 years old, valid FOID, can't be convicted or found guilty of certain crimes, not subject to pending arrest or other disqualifiers, can't have been treated for various addictions, right? Hearing no objections, I think everyone agrees, the judge says. Applicants must complete firearms training and must be certified by a certified firearms instructor. Can we agree on that? Then says he's willing to give the statute to the attorneys, but a lot of crosstalk after that. Somebody had their microphone open on the phone, and they were talking about how they need a ladder. It was kind of interesting. Cook County attorney then says they agree with the statute and don't take issue with the various points that were brought up. The judge then says he's trying to get evidence where the motion was devoid of evidence. So he continues to go through other CCL requirements, including the renewal periods. Any evidence that any of these plaintiffs in the case, again, 4 plaintiffs in the case, did not complete complete firearms training, any evidence that the firearms instructor for the plaintiffs was not properly certified, any evidence that the 4 plaintiffs were not found by ISP to be qualified to have a CCL. Can we all agree that the director of the Department of State Police is appointed by the governor? Anyone to doubt the competency of the ISP director to conduct the operations, including the CCL? The attorneys replied no. Then the judge says the governor could remove the director if there were concerns, right? And the judge asks and takes no objection as a yes. I'm not aware of the governor's thoughts on ISP director one way or the other, the attorney said. The judge then discussed the ISP must find the CCL applicant does not pose a danger to themselves or others. The attorney agrees that such criteria must be met. Any evidence they're not fulfilling that mission? Not that we're aware of, the attorney said. Then Mission of Concealed Carry Act, that no CCL is issued if someone's a threat to public safety. Cook County's attorney said that despite the goal of ISP, it could have an effect into... It could have imperfect information before granting a license. Then the judge says any evidence of that. And then the attorney said, I think the Concealed Carry Act provides limitations on issuance if someone is determined to be a threat but not aware if they can make a determination that they could be a threat in the future. Later, she said that if they are a threat, a license could be revoked. Any 4 plaintiffs found to be danger to themselves or others? At time of issuance, no evidence, the attorney says. The judge then said there's a lot of discovery in the case, and surely the state and the Cook County attorneys investigated the plaintiffs thoroughly. Anything in there that would show that they were a threat to public safety? Nobody spoke. I'll take that as a no. Any evidence the 4 plaintiffs had any objection from any law enforcement agency? Not to our knowledge, the attorney said. You guys are the state with resources to investigate. Any evidence? Not aware of any. Then they talk about the CCL review board with 7 members, and they review objections by law enforcement agencies for CCL holders. The CCL board members are appointed by the governor. Any evidence the governor expressed concern about the competency, diligence of the review board doing their job? Can we agree that if there was a concern that a board member not doing their job properly could be removed? No one objected. Can we agree that it's important that the members of the review board were qualified, diligent, smart, etc.? Then they discussed the chair of the board, Donald Wilkerson, as a former magistrate, someone who fits those characteristics needed, Judge Johnson said. Motion then mentions other members of the board and asks if for any reason they can't do their job, any concerns about anybody on the review board not able to do their job. No one speaks up. Is that a no? The judge said. Are they still on the line? Because nobody was speaking up. So then you had some people speak up and said they have no disagreement with what the court said. Any reason to doubt that the 4 plaintiffs in this case were not properly licensed CCL holders? No. Any reason to believe the 4 plaintiffs in the case are a danger to himself, herself, or others? No. Any reason to believe that they are a danger to public safety? The state's lawyer says that a study shows increased firearm carrying increases shootings and says it was an expert report shared by Cook County. Cook County attorney said that's with regard to the reports, it's the opinion that anyone with a firearm discharging a firearm in close proximity of a train could hit a bystander in general, not specific to the plaintiffs. But then the judge asks, what about those who are trained? The attorney said the study's outcome was in general. So his view is that everybody is a public danger that's carrying a firearm, the judge said. Our review of plaintiffs did not reveal any specific training of discharging a firearm in a close-moving vehicle. The judge then asked if evidence was gathered about plaintiffs' ability to handle firearms, and did defense experts conclude anything? The attorney said that their experts did get depositions of the plaintiffs and other evidence, and his opinion didn't apply to the plaintiffs. He reviewed the info of the plaintiffs, but the evidence didn't alter or sway his opinion in one way or the other that they had the training to discharge a moving closed vehicle. So anyone carrying a gun is a public danger. That's what the judge asked. And then the attorney cites a story out of New York State. One example, good for all, the judge responded, and he just told them to stop. Then the judge discusses the motion to stay or hold that ruling pending appeal. There's no class action. He says, I didn't issue a broad sweeping judgment. It was focused on 2 sets of people for 2 sets of public transportation. Granting a stay is very discretionary. Then the judge talked about, the different types of conclusions that judges come to with these types of stay requests. It's an extraordinary position to grant a stay. The purpose is to relieve the losing party from changing behavior. Talks more about how to determine if a stay is warranted, likely to succeed on appeal, and irreparable harm are a couple of the standards. Then the judge reflects on appeals judges' thinkings on the standards. And the irreparable harm standard he focused in on. Harm cannot be speculative or theoretical. Quote, you can't speculate that just because I'm allowing 4 specific plaintiffs to carry handguns for self-defense that all hell's going to break loose. That's a direct quote from the judge. There's not certainty or immediacy of certain harm, he said. And he mentions a footnote of a news article of people saying that they're going to bring their CCL on public transit and says it's not good to get legal advice from newspapers. And he mentioned the Fourth Estate's important, but he said it's not a good idea to get legal advice from newspapers. And he says even the plaintiff's attorney, when we talked to David Siegel here with Illinois in Focus Daily, he specifically said, don't, wait further, get legal advice. But the judge says that there hasn't been any evidence of any CCL holder carrying concealed weapons onto public transit, and there's no immediacy, no certainty, no evidence, no affidavit from anybody about arrests, no affidavit from the chief of police of Metra. He says you don't even really see police on Metra. And he continues, I've been presented with no evidence. This is an evidence-free motion. He says they just don't like his ruling. A lot of people don't like my ruling, the judge said. No arguments have been presented to me other than we think this is constitutional and we stand by it. The Second Amendment, like other rights, the judge said, is the Constitution is personal, protects people, not places. The Second Amendment's a personal right. It's not all encompassing, he said. There are limits, as the Supreme Court of the United States laid out in Heller and Bruin, in limiting certain places. But the judge, just thinking the judge is wrong isn't good enough, he said. So he says, my order again was not some far-ranging judicial activism, just review what was brought to me. The case was about the 4 plaintiffs wanting to exercise their Second Amendment rights. And he talks about his ruling being characterized as unsettled by the appeals court. He says he would like more clarity from the Supreme Court of the United States about all this, but the federal judge says the first 2 elements of granting a stay have not been met, and the expressed important value of people being able to exercise their rights. And he says after going through all the detail on how to obtain a CCL, there's zero evidence that these 4 plaintiffs are not properly licensed, zero evidence they threaten public safety themselves or others, no evidence they didn't go through the training, that their instructors weren't qualified. He says, I'm not seeing harm to the public, and the fact that some lunatic murdered allegedly sleeping homeless people doesn't carry the day at all. He goes on to say it doesn't even come close to meeting the burden. Don't see the harm of people exercising their constitutional rights. Judge Johnston, federal judge in the Northern District of Illinois, says he's confident in Illinois State Police and the CCL Review Board that they are going to do their job correctly, and if they thought there were a problem, they would be removed or somebody would have their license revoked. The argument that the balance weighs in favor of the defendant because plaintiffs don't ride transportation much, that was an argument that was made. That cuts both ways, the judge said. If they don't ride much, then they won't light the place up. Maybe they don't ride much because they want to carry their concealed firearm. Lack of evidence that the defendants bear to establish the public safety concerns not met. Then he says the motion to stay is denied. He says no sanctions being issued on the lawyers as they had this pretty lengthy conversation, and no sanctions. But he said that they're to be held to a higher standard. Quote, this isn't a Facebook post. This is already a highly charged issue. We don't need to increase it with allegations of mass murder in connection with a court order. That doesn't help anybody. And then that's all. The court is adjourned. Fascinating, conversation there with the attorneys for the state and also for the Cook County, getting some verbal lashings from the judge. So if you missed that, listen, I encourage you to follow me on X because we'll be doing a lot more of these as the cases continue to not just focus on concealed carry, but a whole host of other things as well. Just a note, I have yet to get any info from Illinois State Police about a new list of banned guns, and we're still waiting for any outcome from the Southern District on the gun ban. Expect that in, about 2-3 weeks or so. We'll obviously be tracking all of that here. With Illinois in Focus Daily, like, subscribe, hit that notification bell, and join us each and every weekday morning for Illinois in Focus Daily with America's Talking Network.
this was simple. It was the drinking water. I mean, Scott Bennett and I sat through hearing after hearing after hearing to protect the aquifer, to avoid this type of thing.
That's State Senator Chapin Rose several months ago during spring session in the conversation about the carbon capturing and whether or not the state of Illinois was going to allow for carbon pipelines to traverse dozens of counties across the state in an effort to capture carbon from, factories and energy producers and then pipe it into the ground, deep into the ground to store it. It is Illinois in Focus Daily. I'm Greg Bishop. Thanks for being with us, and subscribe, hit that notification bell with America's Talking Network. So this was clearly a major issue throughout most of last year, with multiple organizations trying to apply to build carbon pipelines, and the local opposition bringing together an interesting coalition of environmentalists and property rights groups, because you had farmers saying they didn't want this pipeline going through their area because, well, if the pipeline bursts, carbon dioxide in a gas form, in a liquid form, it can be deadly, choking people out. So clearly there was concern about that, but there was also concern about the water supplies in some of these areas. So the project, the Mahomet Aquifer Coalition, the Protect Mahomet Aquifer Coalition, putting out a news release about ADM announcing that it's temporarily paused carbon injections after detecting seepage of brine from a Seconds Deep monitoring well, just weeks after the company was cited for violating the Safe Drinking Water Act for a similar leak. So ADM's letter to the U.S. Environmental Protection Agency, sent in September of this year, revealed that the initial data indicated brine movement between rock layers 5,000 feet below the surface, and the seepage was detected during tests required under a proposed EPA order, followed a July inspection of the first leak by EPA. At that time, this coalition said inspectors found carbon dioxide had leaked into areas where it wasn't allowed, and that ADM didn't follow its emergency plan or properly monitor the well as required by its permits. So this was, again, something that was talked about in a Senate hearing back in May. And State Senator Chapin Rose was asking about, the concerns of, the different types of pollutants that get into water. A natural gas leak polluted some of his residents' water supply, where they could literally light it on fire, he said.
This is the same EPA that 8-9 years later, the Eisman family still can't drink their damn water. You can light it on fire. Our Attorney General saved the day by making sure that everybody got a check in the state government. EPA got a check. U of I got a check. Everybody got reimbursed. You know who didn't get a check? Was the people who can't drink their damn water. They still can't drink their water. You can light it on fire, though. You can light their water on fire. Yeah, I know carbon's different than methane. But why on earth wouldn't we learn our lesson here and simply protect the aquifer? Mr. Webb's wells are not on the aquifer. The Gibson City project is not on the aquifer. Why would we just make it plain as day? We're not gonna drill on the aquifer. We're not gonna store it under the aquifer.
So this was during a hearing where you had the manufacturers group and environmental groups coming together on a bill that would put a moratorium on the pipelines that are being built, like a 2-year moratorium for those pipelines to traverse over multiple states and come through central Illinois, going across tons of property in many counties to dump this carbon coming from all over into the ground in Illinois. So that there's a moratorium in place. However, they do have some independent, smaller scale footprint projects like ADM, for instance, that's capturing carbon. They're not requiring a pipeline there, but still they're putting it into the ground. And with this leak that's been reported, raising substantial concerns, Rose saying that he just doesn't trust the government to keep an eye on this.
I'm sorry. Government bureaucrats who failed us already are our protection.
So, he's frustrated by that. Governor J.B. Pritzker asked about this yesterday because the Mahomet Aquifer in particular, it supplies drinking water for about 1 million people. And if ADM announcing that they had to pause their carbon injection project because of continued leakage around there, how concerning is that? Here's the governor being asked about the ADM leak yesterday during an unrelated news conference.
Well, I think that ADM made a good decision to cease operations on their process, and make sure that we're investigating and getting to the bottom of whatever the challenge is there. It's always a concern, of course, when someone's not able to meet the EPA standards. These are federal EPA standards. And I think that the EPA has taken proper notice as well. So I'm glad of that. I think that we got to continue to pay attention to it. Fortunately, there's no danger to the Mahomet Aquifer as a result of any of what's gone on at ADM.
But still, those concerns about the potential impact to the aquifer or any other sole source drinking water, as you've got efforts underway at the State House to try to curb any type of encroachment on such types of drinking water supplies. So what about those aquifers? What about the Mahomet Aquifer in particular? Again, the governor being asked questions.
Well, I think we should do our best, everything, to make sure that we're protecting the Mahomet Aquifer. I'm not sure that bill is the right answer to that. I mean, there are federal regulations already in place, and that was built into the bill that was passed last spring on CCS. So, we've got 2 years here. The whole point of that bill was we're going to put in place a framework. We're going to evaluate as we move forward what the federal government is going to do, because we're waiting for them to come out with some pipeline standards, as well as other work on the regulations around CCS, because this really is relatively new, and Illinois is in an it's an unusual position anyway to take advantage of and make sure that we're reducing emissions using CCS.
Again, CCS, carbon capture systems, I think. The governor saying, hey, the federal government's overseeing this, but I'll just revert back to what Senator Rose said back in May.
I'm sorry. Government bureaucrats who failed us already are our protection.
So clearly some concern as to where this goes. We'll be watching this as well because, through Central Illinois, you've got multiple carbon capture types of operations that they're attempting and moving forward with. And the idea is to, help capture these pollutants and stuff it into the ground, and possibly in the future they'll figure out a way to use it for energy. But a lot of opposition. And again, it's not just environmental groups that are concerned about it. It's also property rights groups that are concerned about it as well. It was a heated debate during spring session, all throughout even last year, with the filings to build these carbon pipelines being halted and attempts to restart those applications being halted, and then the law saying a 2-year moratorium. But that hasn't stopped the potential pollutants of, isolated carbon capture systems that aren't connected to a pipeline going across the state. Obviously, drinking water, extremely important. No question. All right, it's Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell with America's Talking Network, and wake up with us each and every weekday morning as we break down the news you need to know. Recent lawsuits highlighting abuse of children over many years at facilities that are funded by the state of Illinois taxpayers. And Governor J.B. Pritzker being asked about that yesterday. Good morning, I'm Greg Bishop, Illinois in Focus Daily, part of the Franklin News Foundation with America's Talking Network. You can like, subscribe, hit that notification bell, and join us each and every weekday morning. So, sexual abuse at youth detention centers, a huge concern as children are considered the most vulnerable in society. But in September, there were hundreds of people who filed lawsuits alleging sexual abuse at Illinois youth detention centers between 1996 and 2021. Injustice Watch, they are a news organization, a nonprofit that focuses on the Cook County court system. They have this article that they published several weeks ago, and let's bring this up. Abuse allegations went unchecked for years, at a state-funded center for troubled foster kids. Once held out as a national model, a potentially connected Chicago center for troubled youth was quickly shut down by state officials in June after allegations of sexual abuse by staffers, sex trafficking of young girls, thousands of reports of violence, and years of failed oversight. And you can go through and read this yourself. Again, it's Injustice Watch, a nonprofit that looks into the Cook County court system. And it goes on to talk about the move to close this center, Governor J.B. Pritzker taking those steps, and the list of alleged transgressions, many seemingly overlooked by state officials for years. And those transgressions include sex trafficking of minors, staffers who should never have been hired in the first place because of disqualifying prior arrests, overlooked claims of guards using sexual innuendos with children, sleeping on the job, sharing pornographic materials amongst themselves at work, and thousands of reported violent attacks against young residents. So clearly some major issues there. And the fact that these allegations span from 1996 to 2021, raising the alarm. From my understanding, we are going to hear from some Illinois Senate Republicans about this tomorrow. But Governor J.B. Pritzker being asked about this in particular, the hundreds of people alleging abuse at facilities funded by Illinois state taxpayers.
To anyone that this has happened to or may have happened to, I mean, this is unacceptable, and we need to make sure that we're doing everything that we can to keep the children that are in the state's care safe. And so we're paying very close attention to this case. Not going to get into the details here because it's an ongoing case. I'll point out that there are some serious allegations that are involved in here. I also know there are law firms who are, calling everybody from years gone by to ask if they'd like to be part of a lawsuit like that. And so we'll probably see more people joining a lawsuit. Just guessing, that tends to be the way that the plaintiff's bar works. And so, we'll pay close attention. And again, as we're operating these facilities, we're looking at everything, the allegations that have been made, to make sure that this isn't something that's an ongoing problem within those facilities.
The people who brought the lawsuit say that it is.
Well, no, the people who brought the lawsuit say that it has happened to them in the past. I'm talking about in the present moment with these lawsuits filed, right? We can see from the lawsuits what the allegations are. And so looking into making sure that that isn't happening today in the facilities is something that the state is obligated and, will continue to do.
But again, to Injustice Watch, looking at the Cook County records here, even after one facility closed in June, records show a 34-year DCFS veteran tried to persuade center officials to backdate critical child protection plans amid an independent investigation by the agency's inspector general. It was a move DCFS officials now acknowledge was a misstep. Made in, quote, sheer panic. So, these types of things being investigated more and more. But what about those who may still work at the agency despite all of these allegations from a couple of decades?
Again, I'm not going to, make specific comment about the lawsuit other than to say that we want to make sure we're looking at everything, the allegations that are being made, and interviewing the people that are allegations have been made against. And of course, we don't want anybody working for the state that is doing anything that is endangering these children.
So Governor Pritzker clearly has a lot to talk about this in the future. As I said, Illinois Senate Republicans expecting to have a news conference to address this. I imagine they'll address some other things as well. But we'll keep you updated on that here with Illinois in Focus Daily. Like, subscribe, hit that notification bell, and join us each and every weekday morning, giving you the news you need to start your day with. All right, Illinois in Focus Daily with America's Talking Network. Driving along the highway and you see an emergency vehicle up on the right shoulder, Are you complying with the law and slowing down and moving over? Are you using a GPS with your phone hooked up through, Android Auto or CarPlay or whatever Apple's device is? Well, soon you'll be getting notifications through Google. I believe right now, Waze is going to tell you when there is an Illinois State Police officer stopped on the side of the road, either helping with an emergency or moving, to tell you that there's debris in the roadway in certain areas. Very useful, but I would imagine some civil libertarians still kind of freaked out about all the GPS stuff. All right, it is Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell with America's Talking Network every morning, waking you up, giving you stuff to start your day. So Illinois State Police joined the governor yesterday to discuss a new initiative that they're partnering with Google Public Sector and Waze so that Google Maps can have updated information for drivers. So here's Illinois State Police Director Brendan Kelly talking about this yesterday during a news conference.
Since I've been director of the Illinois State Police, I've been to way too many hospitals across the state, stood by way too many hospital beds, and cried and prayed with way too many families, and spoke at way too many funerals, in part because of life-altering and sometimes deadly crashes that violated the Move Over law. One life, one injury, one crash is too many. Every time move-over crashes are preventable if people simply slow down and move over. As chair of the Move Over Task Force, signed into law by the governor, the ISP and our first responder partners looked to technology for a way to keep our troopers and the public safe. Thanks to our partnership with Google Public Sector and the Waze app, drivers now can have advance warning when ISP officers are handling a crash or dealing with a car broken down on the shoulder or debris in the roadway. This means the preventability of a crash can increase and the risk to our officers and motorists can decrease.
Pretty neat there. I will say, sometimes when I'm on a road trip and I see, a speed trap icon on the Google, map, I take note of it. It's even now asking, is that speed trap still there? I kind of question that. Is that legal to... It's like somebody holding up a sign, a mile ahead of a DUI stop saying, hey, DUI stop, pull off before you get there. I don't know the legalities of that, but regardless. So Google is now soon, in the weeks ahead, going to have this type of information that Illinois State Police is going to be providing. Again, that type of information, they're going to get a notice, slow down, move over, about crashes, traffic stops, motorists assists, debris in the roadway, all of that being generated by Illinois State Police. That message, along with the officer's GPS coordinates, are being fed to a Google Cloud, where they transform it into and send it to Waze. As drivers approach the GPS location of the ISP trooper, they will see a police crash or disabled vehicle icon on the screen of their map and receive an alert, slow down, and move over. So I think as it is right now, it's more, Google analysis of traffic patterns that might show, the highway area is red. It's pretty accurate. Sometimes I do see, construction sign pop up and maybe IDOT's working to provide that information. But getting these, short duration types of incidents, crash or debris, chunks of tires in the road, which are always a frustration, especially if there's high-speed traffic moving around. But it'll be interesting. Now, what about the notifications? The director of the state police talked about, listen, people, even if they don't get these notifications, even if they're not using their phone and get the notification through their GPS hooked up to their car, which, by the way, it's illegal to drive with the phone in your hand. Definitely just plug it in, and if you got a modern vehicle. But some people don't want that. They don't want all the bells and whistles and all the tracking that happens there. I can definitely sympathize with that perspective. But regardless, another conversation for another day. Maybe I take that to my private channel with Bishop on air. Should people adhere to those notifications? how can they adhere to them when they're not using a device like this?
Whether or not they get a notification, they still have to obey the law. And if they've violated the law, whether it's failing to slow down or move over, or they're speeding or driving recklessly, whatever the case may be, the law can still be appropriately enforced. So this is not in any way a factor in determining our enforcement. This is really designed to be prevention. This is designed to empower all of us that are on our interstates, on our roads, to be given information ahead of time as they may be coming into an area where an officer is conducting a traffic stop or is had pulled someone over maybe for a motorist assist, or there's some debris in the road, a couple different scenarios that they could be doing some type of normal activity that they do on our interstates, and being warned of that so that they can not have to get a citation. We want them to obey the law. We want them to slow down and move over, and this is designed to empower people to obey the law, because when they obey this law, they are safer, the driver is safer, and our troopers, other first responders, firefighters, EMTs, workers that are out there on the road, they're all safer. So this is not a new way for us to issue more citations. This is a new way to prevent terrible things from happening and save lives.
And I got to tell you, I mean, when I'm driving, I feel like I'm a courteous driver. The other day I was on the highway and saw a disabled vehicle on the right lane. And then I was in the left lane, and I was right up against a semi-truck that was in the right lane. I could have, sped up crazy to get in front of the semi-truck so he could pull over. I didn't. I just slowly came back down, flashed my lights, and the semi-truck came over and got in the lane and avoided the disabled vehicle that was on the right shoulder. Being a courteous driver is not difficult, right? And seeing emergency vehicles on the side of the road, construction crews on the side of the road, slow down, move over. I mean, it's the law in Illinois. More coming, though, of course. Right now, Waze has it, but Director Kelly talking about how they're going to continue to expand this.
So we hope every single app that has the ability to provide this type of notification, we hope that is the trend. But we have to start somewhere, and we had a good, malleable and cooperative partner with the Waze app and with Google. So we began with Waze. The platform and the structure was there to do that. We're moving on very shortly to Google Maps. That's what's next, and that should be coming here shortly. We're excited about that. And then we really hope this becomes the standard. This should be the way it's done on every app that people are using when they're driving. And this is something that we hope is not just used in the state of Illinois, but is something that can happen across the entire country. We're not the only state that's dealing with this very difficult public safety challenge.
Since 2019, 2 Illinois State Police troopers have been killed, 9 seriously injured, 51 others injured in move-over crashes. So that's just a statistic from Illinois State Police. We'll see this, obviously, with state police providing their data to Google. I mean, everybody else on the road's already providing their data to Google if they have their phone in their pocket. It's really just pretty advanced technology, but it's also a spy device. I mean, let's just admit it, right? Anyways. All right, like, subscribe, hit that notification bell. Illinois in Focus Daily, each and every weekday morning, hooking you up with headlines you need to know. I'm Greg Bishop. Follow me anywhere. Just search Bishop on Air, and we can connect that way. All right, that was a jam-packed show. Hopefully you guys are better informed. I got to get out of here and get on with my day. I think this is one of the longer Illinois in Focuses that we've had, going in at 47 minutes. So, and I think the stream has been decent. Might have to get another CPU in here just to alleviate a little bit more of the hiccups. So I'll be talking with management about that. It is Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell with America's Talking Network, and go to thecentersquare.com for the latest headlines of what's going on. And if you can't make the live stream with the 150 people in there right now, chatting it up with others in the chat room on YouTube, well, you can also listen to the show via podcast. Go to your favorite podcast service and just search Illinois in Focus Daily and subscribe there, so you can stay updated with what's going on. All right. TheCenterSquare.com. Get the newsletter. Like, subscribe, notify, YouTube with America's Talking Network, and get the podcast for Illinois in Focus anywhere. I'm Greg Bishop. Have a great rest of your Thursday.